Good morning. How are we feeling? All right, good. I hope last night wasn't too rough on too many of you, and maybe, oh good, we have more folks coming in. That's great. So Eric, thanks for the kind introduction. And it's amazing what you can get done over some barbecue. So, and I think that was 4 years ago. Yeah.
I forgot to mention your firm. Did you mention who you're with?
Oh, Jackson Lewis. And so, in fact, I think in the program, it had my former firm, and last year was with a firm, Thompson, McMullen, and now with Jackson Lewis. And but still doing the same thing, still the same guy. But since then, there we go. That's my topic, OSHA under Trump. I guess we better talk about that. So, I don't know if you noticed, we had an election last fall. Did anyone notice that? Yeah. So, not only, a lot of things have changed since last year. And I remember this time last year, I came up and I talked to you about how to be an OSHA whisperer, how to speak the language of regulators, how to learn the language, to know the person on the other side of the table, or the person, the regulator, and know the language, know their interests, know where you are, be aware of all those factors, and talk to that person in a way that they can understand you, and so that you can get a better result. Well, now that we've had an election, some of that is changing. And so I thought it'd be very timely to talk to you about how OSHA is changing and pull out my crystal ball and talk to you a little bit about where I think the agency's going. And all I can say is strap on your seatbelt. It's going to be quite a ride. It already has been, hasn't it? It's been pretty interesting every morning. The headlines this morning, even this morning, the headlines that come out. I mean, we are in for a wild ride for at least this 4 years. So I thought I'd talk to you about OSHA under Trump. And this colors how, and I try to also, there are a couple things I want to do. One is I'd like to make it practical as possible, because I know for your day job, you have to deal with the agency, but you also have to deal with your business, you have to deal with competitors, you have to deal with logistics, you have to deal with all these things, the economics of what you do. So I try to be very attuned to that and try to talk about how this would apply to how you do business. And also, I want to have a conversation. So I can talk, I've got a whole bunch of things that I'd love to talk about, but I also try to make sure I keep it very casual. I want to talk about what you want to talk about. So I try to keep it, so please participate, jump in, speak up. If you have questions, if you want to take it in a different direction, that's great. This hour is not mine, it's yours. So with that, Eric mentioned that I had served as a labor commissioner, and I did. And so I was in charge of enforcing OSHA. I'm on your side. I now, as a practitioner, private practitioner, I represent businesses that might be cited by OSHA, but also like to try to keep people out of trouble. So if it's giving advice and talking to you, and trying to speak about, okay, this is what's going on the regulatory side. This is what they're going through. And so if you can actually relate to what the agency's going through and what the person on the other side is dealing with, then it helps you. What they're dealing with now, and I empathize a little bit with the agency, they're dealing with whiplash. And I was very attuned to that. Every time an administration changes, not only do the regulations change or what they try to emphasize change, but the way they enforce the law, the way they try to bring safety, make safety a reality, and that is just as important. I will tell you, normally when a reg comes out, a rulemaking comes out, a rule gets put in place, hello, silica, I think sometimes we have a tendency to hyperventilate maybe a little more than we need to. And so, because what we sometimes miss is who's on the other side and how are they enforcing it? How are they making this reality for us? That is just as important. There's a saying, and I do some work in DC, that personnel is policy. What that means is the rules are important, but what's also just as important is who's on the other side. Do you have the kind of trust, the kind of relationship that you need? what's the viewpoint of the person that you're dealing with? Personnel is policy. Who is in place has a whole lot to do with how things are getting done. And so right now, with the new administration coming in, and there are dynamics that are happening right now in which we don't have the assistant secretary in charge of OSHA in place yet. There's a lot of speculation as to who that might be. I have my thoughts, and I think it's going to happen pretty soon. And then the deputy. But the personnel who are in charge now, while they're waiting for that assistant secretary to come in place, they're reading the tea leaves. And those that are staying on board with the agency and who are trying to not steer it too much, but be attuned to where this administration is going, they're trying to actually, they're reading the tea leaves and they're seeing, oh, okay, I think I have an idea where the agency is going now, and they're adapting. That's very important, and I'll tell you about in several ways in which they're adapting and how that's important. But and another thing is that we have a labor secretary who has been in place and it has been quite aggressive actually on the OSHA front, has been much more directly involved in the OSHA front in the absence of having leadership at OSHA and really getting involved in OSHA. And so I was surprised to see that. But we have an administration that is really is being very active in OSHA, even without the leadership being in place yet. So let's go ahead and get started and jump in. Okay, so here are things. Let's see if I can I can use the laser. There you go. All right. Here are some things that I think are very important right now. By the time my presentation is done, there may be a new headline, and everything might be out the window, the way things are going up in D.C. All right? But I'll talk about the increased penalties and the enforcement agenda of the agency. I'd like to talk about the record-keeping logs, electronic record-keeping. Who's a fan? Who's a fan? Nobody? Nobody? I didn't think so. Let's see. Oh, guidance that's coming out of the agency. Some of the enforcement delays that are happening now, what's happening on the voluntary compliance front, and just a few things about reading tea leaves. So let's jump in. Okay. Have you heard they increased the penalties last year? Is this news to anybody? So what happened? The penalties had not been adjusted for quite a while. Now, there's some politics involved in this, and I'll speak a little bit to that. I'll try to be Switzerland. I'll try to be neutral. If I do a good job, you won't know which side of the aisle I fall on, and what my biases are. But sometimes I let it slip. But so last year there was the adjustment of the OSHA penalties. It was nearly an 80% increase, and for some, that was an increase. For others, they called it a correction because they had been frozen for so many years. Well, what happened is it was really a compromise in D.C. because there are certain things that Republicans wanted, there are certain things that Democrats wanted, and one of the things that a lot of the folks on the regulatory side wanted, and some of in the administration, was correcting the penalties back to a point where they were before, and then continuing to increase according to the consumer price index. Well, that's in place now, and so a Republican Congress passed it, and so that is in place now. That is slated to continue for eternity, or for however long we're in business. So that is going to continue. That's slated to continue to increase. So those $7,000 maximum penalties for your serious violations, now they're at $12,700. The willfuls, the repeats, the ones that you could max out at $70,000, they can jump up to $127,000. So, and they're continuing to increase. That's what they're slated to do. My personal thought is, I think that's going to stay in place. I think the increase that has happened is going to stay in place. Partly because it was passed, but it was a bipartisan bill, and so it was done at the initiative of Republican leadership. I think those penalties stay the same. I think they stay where they are. Where I think the change is, and this is a personal prediction, I think the annual adjustment every year, keep an eye open. Now that's a small change every year, but over time it grows and it makes a difference. I think that might be on the chopping block. We'll see. And let's see how or if Congress can pass a budget. And if it can, then I think that might be one item that might be on the chopping block. I told you that when these things happen, sometimes we hit the panic button. You know, yes, you have rules like this that are put in place, but who is in place to enforce it makes a huge difference. Some of you, maybe half of you, are in the state plan states. How many folks know what the state plan state is? One? This is very important. This is really important. If you're in the 26 states in which they have a state plan, like mine, I'm in Virginia. We run our own show. If you live in one of those states, these things matter because you have to get it perhaps through your own General Assembly. You have to have your governor on board. You have to have your state actually following what OSHA does. And so that's very important. The states, in half the states in the U.S., and I'm sorry for my Canadian friends, we have a federal system in which the states often do what they want to do, and it's just not it's not common to most of the rest of the world. But that really matters because that penalty increase may not necessarily kick in the state where you are. Now in Virginia, we did. But all the states have to do is have a program that's at least as effective as the federal program. So, but also, what's also much more important is, say, in Virginia, where we run our own show, and half of your states do as well, this penalty increase isn't necessarily happening even if it's in the law. I told you, personnel is policy. Who's in place has a whole lot to do with how it's implemented. So, in Virginia, we're easing into the water. And you may be in a state where they're easing into the water. And so they may not be doing the entire 80% bump, even though technically it's in place. They may say, well, yeah, we've got that. We even went federal compliant with our new penalties. But we decided, we don't want to go that far that fast. You may be in a state where they're doing that. And so your penalties may not have changed much. I'm probably not talking to the right crowd because I'm sure none of you ever get OSHA citations, right? Not you guys, no. So, but it's probably more for the folks who are not in the room. But that's important. Thoughts on penalty increases? Too early? Not enough coffee in our system yet? All right. I'm working on mine. Record keeping. Our favorite change at OSHA in the past year. So, one of the really important things, and we see the rules get changed, but again, who's in charge has a whole lot to do with how things are happening. And there are delays that are put in place. And now, this is one of them. The rule has been in effect for the electronic record keeping. How many folks are kind of up on what's happening with electronic record keeping? Yeah, it's those 300 logs, and you have to put them in. And August 1st is the date they say they have the electronic system ready to go. It's really, even in the state, I'll tell you, even for OSHA, it's extremely frustrating on the OSHA side because trying to get the technology online and get up to the point where they can actually implement these things, there are delays on delays on delays. And so I'm not so sure how seamlessly that's really going to go. In fact, OSHA has pushed back its enforcement on this back to December. Now, I told you before that OSHA doesn't have an assistant secretary in charge yet. My personal prediction, I think September. I think September is the month when we get it in place. Partly because we have some of these delays that are pushed back here. Maybe we get it next month, but I'd say within 6 weeks. I think they're getting close. And I could be wrong, it could be a little quicker, but I don't think it's going to be any later than that. But they're pushing these things back on the electronic record keeping. All right, crystal ball time. What's going to happen with this? I don't think they can roll this back. I think it's too late. I think it's out the barn. I think it's happening. Now, it came under such tremendous opposition, especially from the regulated community and from safety organizations. There are many safety organizations that came out against this. And it's tied up in litigation. All this stuff is tied up in the courts. Folks like me, the lawyers, we're tying these things up in court. I think that they keep the rule. I think that there are two parts of it that will change, and one I'll get into a little bit later. The first part is I think that what will happen is that when the personnel is in place, the leadership is in place, they change the way they do business internally. And how do they do that? I think they don't put the data out on each company as they initially had thought, the plan was initially. I think that, and they can do this internally, they can collect the data, they can push the data out in aggregate. Because part of the opposition was, for a lot of folks, and including a construction industry, is, if you put out our injury and illness logs out there for the world to see, you got some serious problems, okay? They're what we might call due process problems. You have rights. And so if your information is being pushed out as if there was an OSHA violation every time an injury occurred, or there was someone missed days of work, or incident occurred, you're denied your due process right of being able to defend that. You're automatically considered guilty before you have a chance to speak up. OSHA, as you know, has a process. A citation comes out, they come out, they investigate, they issue a citation, you get the benefit of an informal conference, you can explain the information that you have with the person who's with the agency. You get some benefit of the doubt. Maybe you can enlighten the agency and say, hey, you know what? And I dealt with this, and maybe some of you have as well. Every time we had a fatality occur at a workplace, my cell phone goes off and I'm the first to know. And every single one of them, I wonder, what can I do about the next one? Sometimes you can't. Sometimes it's because someone perhaps they die of natural causes while they're at work. It does happen in all professions. Maybe it's something that is employee misconduct. Maybe it's something where they're pointing the finger at the wrong employer. Maybe it's a contractor that is, they're pointing the finger at the wrong contractor. Who knows? But there's a due process. You have the ability to defend or explain and provide information so that you're not presumed to be the one who's at fault. One of the problems with electronic record keeping is that it negates that. That is put out automatically for the world to see. Anyone can tap into the database and see, oh, okay, XYZ company had these injuries occur. Think about it. The press, labor, the politics, local officials, and I've seen heads roll when something bad happened at a workplace. But they haven't yet, I know, this may shock you, sometimes the press doesn't do all of its diligence or have all the facts before they report something. It happens, and I know it's a shocker. Or politicians, they say, oh, hey, wow, this happened over here at this workplace. What's going on over here? And heads need to roll. Well, maybe not. So that's one big concern. That's why I think that when the personnel is in place and the leadership is in place, I'm willing to bet that's where they tweak this so that they can comply with the rule, but make it a little bit more business friendly. So, anyone else having a prediction on that? It could go a million ways. Still too early, Eric. Can we send a pot of coffee around?
Okay, maybe we'll see it in 5 years, maybe.
What's that?
These changes.
These changes?
Yeah, like taking out, if there's a natural cause death on the job, but it was related to a safety issue,
Right. And by the way, the delay, yeah, the gentleman said it could be a 5-year delay before they can figure out what happened if it's a natural death that occurred. And I got to tell you, I mean, when I left the OSHA in Virginia, the lawyers had files. I think it was 120. And they were just sitting on the lawyer's desk. And they are just backed up 7, 8, 9 years. Still haven't been dealt with. They may have filed something in court, and then judges and the defendant and everybody's wondering, well, what's going on here? Nothing's going on. They're just so far backed up. And so that's a huge problem. So by that time, after 5, 6, 7, 8 years, who knows? Who cares? Who's paying attention to what happened with this thing that got reported electronically or got put out there for the world to see through the citation? So you're right. I mean, it could be an extremely long delay, which really, by that time, do you really need 5 or 6 years of bad press and everybody on top of you about something that wasn't necessarily your fault? It could happen. So I think that's a huge concern. Let's see. Guidance. You see, we hyperventilate about the rules, and sometimes we should. Sometimes we shouldn't. Because OSHA, as you know from the last administration, yeah, there was a flurry of rule makings that happened at the tail end of the administration. But really, where a lot of the action was happening, it was in the guidance. It was the guidance that the agency could push out without having to go through the rulemaking process, which, by the way, takes years. I mean, there are rules that were, I think, older than me and still haven't gotten through. The silica rule, gee whiz. I mean, the ball started rolling on that in the 1930s. So, I mean, and it got pushing in earnest in the 70s. It takes a long time for these things to get through. But the guidance is where the agency really did a lot of work in the last administration. So paying attention to the guidance that comes out is important. And here's a big reason why. So, general duty clause, you know that catch-all? When there isn't a reg on point that you can point to and say, okay, this is above the permissible exposure levels. There's no fall protection when needed over 4 feet of height. Whatever it is, when the general duty clause, you know what? There's a recognizable hazard, should have fixed it. That's where the guidances sometimes kick in. Or sometimes they kick in when it's just how you should interpret a rule. So the guidances that came out of OSHA, and if you paid close attention to those got increasingly stronger. I think the guidances are going to get rolled back. And this is a case in point right here on the temporary. How many of you use temps? Okay. Do any of you employ, dispatch temps? Do any of you work for temporary staffing agencies? I think I met, yeah, there you are. Okay, I talked to one of you about this yesterday. So, that's really important how OSHA is looking at the usage of temps. Now, the guidance that came out before and that is still in place now is really OSHA, and OSHA couldn't really get a reg out. They couldn't do a rulemaking on temps. In fact, I think they tried to do too much and ended up not doing it as much as it really intended to. Well, there was a guidance. You're familiar with the guidance that was put out in temps, right? Yeah. And so the OSHA 300 logs, a lot of the responsibility, who's cited, who's on point for if there's a hazard. OSHA put out the guidance saying, you know what? It's on both the host employer and it's on the temp agency. It's on both, okay? But using the criteria that was pushed out, it was saying, okay, it's about who has control over the worker, who has responsibility for the worker, who's responsible if something bad happens, who's responsible if there's harassment of the employee, Who's responsible for their training? Who's responsible for their direction in day-to-day work? You think they're talking about the staffing agency? You guys are usually off the hook. You may not feel like it, but at least as far as OSHA is concerned, if you look at the citations, they're not usually hitting the staffing agency. They're hitting the host employer because that's where the control over the worker usually is. That's where the training often is. You might do basic OSHA, OSHA 30, you might do some basic training with them, but how to train to the specific equipment that's on site at your location, it's usually the host employer. Who's determining the conditions of employment? Are they working outside in the heat? Are they working at heights where they need fall protection? All those, that's the host employer. So responsible for the safety and health of complying with OSHA standards. Hey guys, those of you who raised your hands the first time, I think really that's, and if you look at the OSHA citations, that you're the ones who are in the crosshairs on the temp employees. That wasn't a reg. That was a guidance. And so like I told you, if you don't walk away with anything that I've said to you this morning, that's entirely possible if you haven't had enough coffee. It's this: personnel is policy. Who is in charge has a whole lot to do with how things are enforced and implemented. So it's the host employer. So I think that's one area where, you could see some rolling back of the guidance or some tweaking. And you may not see it in the website, you may not see it in writing, you might see it in the field. Okay? Case in point, when I served as a labor commissioner, I succeeded someone who had a very different background. And he was from a labor background, and it was also very deferential to what was being recommended from the field. I have a legal background, and I have a tendency to jump in there, and I start picking apart, okay, this citation, is it defensible? Would we win? I have an outlook in which I learned the outlook of, you know what, if you can't make sure it sticks, don't issue it. So kind of like what the feds do when the U.S. Attorney's Office. You can bet if there's an indictment that comes down, they already have the case. It's already put together. They have all the evidence. They're ready to go. That's one approach. But if you have, you may have that kind of an approach with that type of review internally inside the agency with the current administration. But we'll see. Have you noticed, what's the kind of people who have been appointed so far? What's the kind of background you've seen of the people who have been appointed so far? Yeah, business. They're not coming from government, not this crowd. They're coming in. And what was the mantra of the campaign? Drain the swamp. Deck chair rearrangers need not apply. They're bringing people in from the outside and changing things drastically. They're trying to follow much more of a business model. Now, there are a lot of stumbles along the way, and you often are dropped into an agency of folks who really know where all the dead bodies are, where all the landmines are, how you do things, how you stall things. But the leadership that's coming in, they're coming from a business background. So it's very important. So this type of guidance, it really comes into play. The retaliation, again, this is guidance right here, okay? So on the electronic record keeping, how many of you are tuned to the retaliation guidelines that came out after the electronic record keeping one? I got to tell you, I must be a geek. I find this exciting stuff. This is really interesting, even at 8 a.m. I got to tell you. So under the guidance that came out, it created a cause of action for retaliation. Okay? Now, the guidance started to define what's retaliation. Who is there? Who is in the driver's seat is so important when it comes to this stuff. So, post-accident drug testing. Does anybody have anybody at a work site who, oh, God forbid, smoked a little weed before getting on the job site? Maybe somebody snuck a little vodka in their thermos on the job site. It happens. Well, let's say one of your guys in the field gets in an accident and you drug test them religiously. Can you do it? Well, there's some controversy out there with guidance that was put out by OSHA about exactly that. In fact, it was a little contradictory to what the law was, and it came out from OSHA. Let's see if I'll boil it down into scenarios. Guy gets stung by a bee. Is it because he has a little THC in his system from a couple weeks ago? How many people say yes? How many people say no? It's okay, yeah. He probably didn't get stung by a bee because he smoked something a couple weeks ago. All right. Same guy working on a machine that doesn't have adequate machine guarding. Had a few too many the night before. It's early next morning, kind of groggy. Who's at fault? Him? How many people would say him? How many would say the machine guarding? It's probably the machine guarding, but you know what? What if he's still under the influence? Could it be that, as we might call contributory negligence? Is it that somebody is under the influence and it's both the employer's fault and the employee's fault? Well, let's say he's out driving and he's under the influence, you can come up with all kinds of scenarios. Maybe he was swerving and trying to avoid something, but he shouldn't have been driving anyway because his blood alcohol content was just too high. Well, so the guidance that was put out by OSHA really froze a lot of people. And it said, you know what, if the person was under the influence, and that you could reasonably deduce that, if the employer could reasonably deduce that the controlled substance was the reason, okay, sure. But if you can't determine that, then no, you can't drug test everybody. And you know what? We have clients that come up to us and say, I don't know what to do now. Should I drug test these guys? Should I, if they get into accidents driving the company car, or if they're hurt on the work site, and we have reason to believe he smelled of alcohol, he was stumbling around a little bit, we're not sure. And so we try to help you play it safe. And we'll tell you, look, you know what? There's OSHA on one hand, and there's liability on the other. And by the way, if you get hit with a lawsuit, trust me, an OSHA citation is the least of your worries. So often we will advise you and tell you, you know what? Treat everybody equally. Have one policy and implement it religiously. Never diverge from it, okay? And if you test everybody, do drug testing for everybody after an accident, keep doing it. And if OSHA has a problem with that, we'll deal with that. But let's keep you from putting people recklessly, from endangering other workers or other drivers by not drug testing. Yes, sir?
So, first of all, how long has drug testing been in place?
Do you mean this guidance here?
No, not the guidance. Drug testing in general as part of employment.
Oh, Lord. I don't know.
The reason I asked, I got
A long time.
and I know it was already there.
Mhm.
Why? I've always questioned this because there's no. I ran a drug testing program and I saw accidents happen, and marijuana stays in the system for 30 days. Doesn't necessarily mean you were impaired when the accident happened. Why hasn't that ever been tested, or has it been tested in the courts? Why hasn't anybody sued and taken it to the Supreme Court or some court to make a decision? Does that ever happen?
These things get litigated all the time.
What happens?
Well, generally, and so I mentioned that if you can't negligent endangerment, and it differs by state, but negligent endangerment of others in the public or others at the workplace is something the employer, as an employer, you're on the hook to it. And if you put somebody into the workplace knowing that this person may be under the influence, then you may be endangering other workers or invitees, people who may be coming onto your job site who aren't your employees. But usually, you're going to have some deference on that if you're acting in good faith. Now, especially on EEOC, the discrimination. Let's say it appears you're being a little selective about your drug testing, and maybe you're testing these workers but not those, and maybe you come up with some reason and say, well, these guys have this level of employment, but those have that level of employment, and they happen to not have the same demographic mix. Yeah, right. So, president of the company can't go take the company car and get a 3-martini lunch and come back in the company car. That you probably would get hit with. I think EEOC is where that would come through. But anyway, what I'm saying is there's more deference on the employer side, or it traditionally has been on that. So you don't necessarily hear about that, but when it comes to OSHA, you have folks who are saying, you know what, we're going to hit them on this, and we think this is the drug testing is. There are folks who think it's a sham. Yes, sir.
You have states now that permit recreational drugs in the workplace. You have a federal law that says really that's not permissible. We have federal guidelines, we have state guidelines. This happens to me like
You're right, and I mentioned that the guideline contradicts the law. And so under DOT guidelines, there's mandatory drug testing. And so OSHA says, oh, well, you know what, because there's a law of more specific application, and that's actually required under the Department of Transportation, that governs. But you know what? Somebody in the agency didn't do their diligence when they put this out. And so it threw everybody for a tailspin. But you're right. So the state and the federal law can contradict. And this is why, so we just tell folks, calm down, take a breath. OSHA should see it your way. And we try to make sure that we have the kind of credibility. That wasn't meant as a laugh line. But if you have credibility, you have a good reputation. If you have that kind of connection, I think it helps. Did I rehabilitate that? Oh, man. All right, let's keep going here. Oh, and the safety incentive programs, that's another area where I think you're going to see some change. So there was guidance that was put out saying, any benefit that you can accrue, I mean, even down to having a pizza for your employees for reducing the recordable injuries and illnesses, that can be right there a violation. Because they lump it in with retaliation. They say, well, incentive programs of any sort that have a tendency to cause employees to underreport in order to get the incentive is just another way of retaliating if they do report. But I think it got to levels where they're saying, well, even having a pizza party to celebrate reduction of injuries can possibly be a violation. And it got into silly town. It really went to silly town. But I think you're going to see with the kind of people that are coming to the administration? Business. If you have business people coming into the administration, they're going to start taking a more business-like approach and saying, well, how do I get folks on board with a key goal I'm trying to achieve? And we do it in production. We have incentives. We have incentives in all sorts of things. So I think we're going to see a little bit more friendliness in the guidance with respect to incentives in OSHA. Another guidance, the whistleblower guidance. So the standard was changed just barely a year ago on whistleblowers. And then OSHA said, well, if there's reasonable cause to believe a violation occurred, okay, the standard was dropped on whistleblower. So then if OSHA believes after evaluating all the evidence gathered that a reasonable judge could rule for the complainant, then you don't need conclusive evidence that there was a whistleblower violation when you fired somebody or you took action against somebody because they blew the whistle. Reasonable cause is enough for OSHA. That's new guidance. I think that's getting deep sixed. That's my personal opinion. I don't know. We'll see. Let's check back in a year. I'll be here. I'm a bad luck penny. I keep showing up. You know that. Let's check back and see. Is this standard inside OSHA still in place? Now, I got to tell you, there's a gentleman who mentioned litigation. Litigate that. I think I'd have a fun time with that, litigating that. Enforcement delays. I don't know if you heard. They're delaying enforcement of regulations that were passed in the last administration. Shocker, huh? Why are they delaying this to September 23rd on silica? It's going to be a new sheriff in town. The Labor Secretary Acosta, and if you look at the last one that was put in place, or the one that was nominated but wasn't confirmed, I tell you, it's telling you what the pattern is. Look at the Secretary of Education. Look at the Chief of Staff. Look at every level of this administration. They're pulling in people from the outside in to drain the swamp. They are not rearranging deck chairs. Not happening. This right here, silica, got pushed back. And they pushed back the enforcement. Now, if you're in a state plan state, and pay attention, if you're in California, if you're in North Carolina, if you're in Virginia, it depends on the state you're in. This stuff matters because this pushback happened in federal OSHA, didn't necessarily happen in all the states. Kentucky pushed back. Now, Kentucky eventually did decide to push back its enforcement to September 23rd. Personnel is policy. In Virginia, you have a labor commissioner who came from labor. Guess what? They didn't delay. It's in place right now. If you're in Virginia, you may not know it, but you didn't get this delay. So it depends on where you are. So most states, and the federal states where OSHA governs, this got pushed back. In a lot of the state plan states, it got pushed back. Not necessarily true depending on where you are. I feel for you guys. I really do. Because the whiplash is happening with the agency. The whiplash happens with you all. And so if there's anything I wish for you is that there's more stability and certainty so that you know how to proceed under the rules and what OSHA is doing and how it's enforcing the rules. I wish that for you, but if you're checking the headlines every morning, I think that stability is not what we're getting from Washington right now. So, like I say, strap on your seatbelts. It's a bumpy ride. The beryllium rule. So there's an executive order. One of the first things the president did, and this is common, a lot of administrations do this, to freeze all rulemakings for now. And then, if you want your rule to get through and to get enforced, then it has to be approved. So, beryllium got caught up in that snare. There are other rules, and certainly in labor rules, and many others. And so they got frozen. And you also have seen that the Congressional Review Act, I'm so geeking out here. How many of you know about the Congressional Review Act? 1, 2, 3. Okay. I'm glad I have a few people in here with me. But Congress, within a certain window, can actually take rules and review them and kill them or freeze them. And so there's a whole slew of rules that were passed under the last administration that Congress grabbed a hold of, and they put the stop on it. So, and that's another way that things have changed. But you have some rules that have been delayed, and I think that September 23rd date means something. Somebody thinks that something's going to change by that date, so that how this silica rule is going to be enforced, I don't know if it's going to be rolled back or if there might be an attempt to roll it back. But again, it's not just the fact that the rule's in place. Personnel is policy. Who's in the driver's seat has a whole lot to do with how this is enforced. Case in point, I keep talking about Virginia, but it's a state I know and love. You know, the agency, in telling folks that it's not delaying the rule enforcement like everybody else or most other states, they said, guys, breathe, relax. Because our construction industry, a lot of our groups, the Associated General Contractors, the ABC, the whole alphabet soup of associations, they were all fighting this tooth and nail. And the agency was saying, guys, breathe. We've only cited a few of these in a matter of years. And so we're going to do a soft enforcement. Or they might do a secondary, what I call a secondary enforcement of the rule, where they're not necessarily going out and looking for silica violations, but if they happen to be there and they notice one, then they might cite it. Or, frankly, they might kind of work with you and cut your break if you do quick abatement, or you work with them, or you ask for best practices. You see what I'm saying here? It's not just the rule, it's how it's enforced and who is the one who's enforcing it. That's where relationships and credibility come into play. If you have those kinds of relationships, you have that kind of credibility, it can make a huge difference. How are we doing? Do we need more coffee? Come on. Hang with me. All right. Voluntary compliance. Oh, man. I love this stuff. This is earth-shattering stuff. So now this administration is going ape crazy about voluntary compliance. They love it. In fact, the president introduced a budget that boosted the voluntary compliance budget by $4 million. And so the compliance assistant specialists, have you heard of those? Compliance assistant specialists, CASs? Yes? Anyone heard of the term? Yeah, they're VPP, they're SHARP, they're the consultation. So all these wonderful programs that try to help you to adopt best practices without having and inviting OSHA in, partnering with OSHA. So those positions have been dying on the vine for years. Well, the president's budget restores most of them. It proposes to put 20 full-time employees back to restore most of the positions that have been cut as of late. It has very specific language, Voluntary Protection Program, and some of you might be familiar with that. VPP, anyone know what that is? Oh, good, okay. So, SHARP, Safety and Health Achievement Recognition Programs for smaller business, yep. So they're putting in a whole lot of new blood and new money into that, and they want to staff those up. Not only that, but they are saying in the budget, president's budget, that we're going to go back, and there's a huge backlog of recertifications for companies that are in VPP, but need to get that follow-up inspection that they do every 3 to 5 years. Or there's a huge backlog in certain regions where there are companies that applied to get voluntary protection program status, and VPP, that's when you have you're super safe, and you're recognized by the agency, and you have a flag that you can put up that says we're VPP, and insurance companies love you, and your workers' comp rates go down, and your injuries go down, all that, and you're partnering with other businesses that are in the program. So OSHA is going crazy over this, and so there are companies that have gotten their act together, and they've done all their diligence, and they submit the application, they're ready to go, and nothing. And a year goes by, and nothing. And 3, 4, 5 years go by, and nothing. Gee whiz. I mean, you put all this time and energy into getting to the status, and the agency doesn't even recognize that it has the application. Talk about disheartening. Well, this administration, and I don't think, it's not that they're not believers in it, but they just didn't have the personnel. I'll add a little editorial comment. In my view, they didn't have the creativity. They said, our dwindling resources, we can't do all these recertifications, we don't have the personnel. Yeah, you do. Yeah, you do. They're not in your building, but you've got them. They're out there. It's you guys. And so the companies that do VPP have what's called special government employees. They're not federal employees. They're just deputized by OSHA to stand in the place of OSHA and help to do those recertifications in the name and in the place of OSHA. In fact, they're often better. Huh? They're actually, sometimes they know exactly what's happening in the industry and know best practices and what's happening and the new developments and know best practices better than the inspector did in OSHA. So now, and I tell you, change in approach, not only are they putting in $4 million in new positions and trying to clear out the backlog, more SGE involvement, those special government employees, those private sector experts in workplace safety. Who's getting appointed into the administration? Business. Who's going to reinvigorate the voluntary compliance? Business. That's where it's heading. And somebody put jet rocket boosters on this thing and said, go, and lit that thing, and it's taken off already. That's before we have an assistant secretary in place. And so that's the tea leaf type stuff. The Safe and Sound initiative, they're trying to emphasize partnership, okay? And I do work on this personally. There's legislation to make the voluntary protection program permanent and make sure that there's a line item in the budget so that it never goes away. Business likes certainty more than anything. It's a bill to create certainty. That's something that may have a chance to go. So this voluntary compliance, they're re-energizing it. They're recruiting people from business to get into it. They want to make it permanent. That's where I think things are heading on the voluntary compliance side. So with that, tea leaves. Look, I would say on the national and local emphasis programs, I'd say look for a light touch on that. Now, they're still for safety. OSHA's still going to be they're still going to try to get us to safety, but I think the approach is going to be different, okay? And so I think it's going to be less national emphasis program from on high. And no, they do it in good faith because it's in response to some incidents that they're seeing happen or trends that they're seeing happening. But I think you're going to see less of it. I think, on the interpretations, keep an eye on those. You see, we look at the regs, we look at the rules, look at this stuff, and it's right there on the website, okay? How is OSHA working with the states on the misclassification issue? Oh, Lord, we could take a day talking about that. Misclassifying employees and calling them independent contractors. Who is in place is going to have a whole lot to do, not only with the guidance on misclassification, but how the administration partners with the states and how that's enforced. I think you're going to see a lighter touch. I think you're going to see a lot more deference for employers who use independent contractors and call them that. I think that's what you're going to see. The enforcement memos. You're going to see a lot of changes in this stuff, and this is on the website. So that's where the one area where you can really look at the tea leaves, okay? Keep reading those headlines. I think you're going to see more support for the states and more leeway for those 26 states that run their own OSHA program. They're going to push it out so that those who are closest to the employer are more in charge of what is a program that is at least as effective as federal OSHA. So I think you're going to see more of a local flavor in those states if you're in one of them. You're going to see where the rules may not necessarily be in place, or they may not necessarily adopt the same rules, or they may enforce it very, very differently. I think you're going to see more of that. So, and look at who's appointed. So, things to do in the meantime, just keep an ay on the focus areas, look at the top 10 violations, keep on top of that stuff, keep checking on what OSHA's putting out. Because if there's something on the top 10, if fall protection's on the top 10, keep an eye on your fall protection, okay? Those are some very practical things that you can do that I suggest, okay? Make sure you're on top of what the record keeping, what's happening on that. So, just because the electronic record keeping is theoretically in place and ready to go August 1st, well, the enforcement of it is delayed. So in that time frame, keep an eye open, and I would cool my jets. I'd cool my jets a little bit on jumping right in on that, lest that rule change. God forbid. Who knows? Could happen. So, yeah, just be ready and follow some of those tips. Developing your safety and health program. There are some great tips for best practices on the OSHA website, and that's what I have. So with that, I think we're at 9. I don't have time for a question, do I? I can take questions in the cafe. She said, get out of here. Our 9 o'clock is starting. All right, that's cool. All right, thanks, folks, and stay tuned.